has to decide its priorities, and that's appropriate. But lo and behold, what I regard and what I think most people regard as an extremely strong case got dropped at a point where the resources necessary to follow through were really very, very small. And so that was surprising to me. Again, each administration can and should set its own priorities, unless the motivation has something to do with the fact that in this particular case, the defendants were black. If the reason for dismissing the case has to do with the race of the parties, then I think that's something that the commission has a duty to look into, and that's why we're doing this case. If that possibility were not there, I don't think it's very likely that this case would have been chosen as a subject for an enforcement report. It's the fact that there is the possibility that race is infecting these decisions, and that would be, as the Assistant Attorney General said, that's not what they should be about. That's why we're looking into this. Not all the evidence is in, but this is something that is perfectly appropriate for this commission to look at, and in fact, I think it will be inappropriate for us to neglect this kind of issue.
Commissioner Kirsnow?
Mr. Chair, voter intimidation is a matter of some seriousness, and we are specifically charged with investigating those matters. I don't know if we had turned a blind eye to some of the other cases that have been cited, Pima, Mississippi, or some of the others. I will tell you that, frankly, had it been brought to my attention, I would have counseled that we should look into those. I don't recall those ever being raised before the commission as subjects for our investigation. But again, had they been, I would have aligned myself with those who would have wanted to take a look at it. I think this particular case was a public case, was brought to our attention, it merited our review, and I will withhold, or at least hold in abeyance, the balance of any other statement on this matter until such time as I've had an opportunity to review the depositions, transcript of the hearing, all the documents that have been produced, and I'm hopeful more will be produced at the conclusion of our investigation of this matter.
Okay, and I'd just like to share some observations. I listened to Mr. Perez, and some of the thoughts that came to mind was, well, I'm just surprised at the cramped, narrow approach taken by the Obama administration on this point. It was very technical, very conservative, just giving me the impression that the administration was just uncomfortable with this case. I was also struck by the fact that the characterization as to who was responsible for the decision, the notion that the buck stops with the administration, it's not clear that that's true with this administration. I kept hearing that Loretta King and Mr. Rosenbaum, with their 60 years of collective experience, were the shot callers in this matter. That strikes me as odd. It is the administration that's responsible for decisions, good, bad, and indifferent. The administration owns it. And hiding behind the decisions of career civil servants, it's not what I expect of an administration that accepts responsibilities for its decisions. In any event, at this point, though, I'd like to say that this concludes our hearing for today. We are adjourned sine die until a later date. We will hold the record open for additional evidence pursuant to 45 CFR sections 702.8. Individuals who wish to submit items for consideration to be included in the record may send them to the General Counsel at the U.S. Commission on Civil Rights at 624 9th Street Northwest, Washington, D.C. 20425. Thank you.